Welcome to 60 Seconds with the Allen Firm. We hope these short videos are really legal tidbits that will help you make good decisions and just clear up some kind of unknown you have for legal situations. So today we have Stephen Cheak. Stephen is of counsel with the firm. And Stephen, I think today the question I have is one we get a lot, and it's a little bit confusing for many, is what is mediation and why is it important? Can you speak into that?
Sure. So first of all, let me warn you that mediation is part of a larger construct that we have in Texas under alternative dispute resolution. That is a class in law school that can take a semester or two. So I'm going to try to parse it down. I'm just apologizing ahead of time.
Yeah.
I tend to talk a lot. So
I appreciate
I'll
it.
try to make it short. So alternative dispute resolution is kind of the overarching mechanism that we use. And what that means is if we can take this dispute out of the courthouse, we're able to lessen the cost. Sometimes we're able to speed up the process and get to a resolution faster. Not all the time, but generally that's the purpose. The more we stay in the courthouse, the more expensive it is. So if we can agree to step outside of the courthouse and use a third party, which a lot of times their ex-judges are the mediators, we can reduce those costs. So mediation in and of itself is a little bit different from arbitration. And you hear that all the time, arbitration, mediation. A lot of times arbitration is binding. It's exactly like a decision from the judge. Mediation is a little bit different. It's a little more laid back. The rules of evidence and procedure, which tend to, again, increase costs in a courtroom because you're taking longer to introduce evidence, that goes away in mediation. It's more informal. It does have a third party which acts like a judge, and that third party basically tries to do what's best for both parties. They don't try to run into the room and make it absolutely 100% one side, absolutely 100% from the other side. They try to find a good middle ground where both parties, and actually, let me pull that back. One of the best mediators I was ever in front of gave us a sheet of paper. And on that piece of paper, he said, if both parties are a little bit dissatisfied with what I decide today, then I did my job.
Yeah, that's good.
It should not tilt one way or the other. And so that's a really good sentence explanation of what mediation is somewhere in the middle. And so you're giving up your time in court to get a judgment by a judge, but you're trading the cost that it's going to be and the time, the extensive time. For example, right now you can't get a jury trial in Tarrant County for next to 18 to 24 months. So if you can get into mediation and decide some of those problems right away, then all the more better for both parties. You can move on down the road.
Well, just in your experience, and real quick, do you see that judges often, before you get to a trial, whether it's jury or just in front of the judge, do they require mediation a lot of times?
That's a great question. Certain judges in certain realms, like in family law specifically, almost make mediation mandatory. You have to go to a mediator before they will set you for any sort of a final trial.
Okay, so that's something that is going to be required in a lot of situations anyway, and something we shouldn't be scared of. It could really resolve the case, up front and early without getting too many costs involved.
That's correct, because if you look at the cost of what a trial is, and you look at what the cost of mediation is, you're talking a fraction of the cost. And the judges know that too. And so they're trying to help the citizens who have to vote them in office. They're trying to help the citizens also reduce their cost.
Okay. That's great, Stephen. That's super helpful. I appreciate you taking time kind of clearing up mediation for us.
Sure.
Thank you.
Thank you. I appreciate it.